What did your father make of your sort of anarchist leanings?
I think basically his view was that the institutions I described might work but probably wouldn't, and my view was they might not work but probably would.
Economist David Friedman, son of economist Milton Friedman, makes a case for privatizing the law. He seeks to not only privatize the creation of law itself, but also its enforcement. This argument is based on anarcho-capitalist principles that utilize the efficiency of free enterprise to produce goods and services, in this case, the law. Many libertarians, free market economists, and those in favor of small government contend that one of the only legitimate and necessary roles of a government is to create and enforce some basic laws that prevent the unauthorized aggression against someone. If the government does this, the argument goes, then the market will be able to operate because private property rights and other liberties will be protected. Dr. Friedman takes this logic a step further and argues that the market itself can create and enforce law, and by doing so, create a more efficient, effective, and equitable system. Government is less efficient than the market at seemingly everything. So, quality is worse and costs are higher when the government does something than when a competitive market does. There are many examples of this. So we should not expect the government to do a good job at creating law.
Producing laws is not an easier problem than producing cars or food, so if the government's incompetent to do a good job of producing cars and food, why do you expect it to do a good job of producing the legal system within which you are then going to produce the cars and the food?
In a separate speech, he notes that when the government gets involved in producing food, we get more expensive food or famine, and when the government produces cars, we get cars that break down. Dr. Friedman says market-created laws would work by having competing rights enforcement agencies that are playing a repeated game. These agencies would utilize private arbitrators and courts based on contracts with other rights enforcement agencies. Individuals would purchase coverage from a rights enforcement agency that meets their criteria. It is like shopping for insurance coverage. These agencies would then protect the rights of their policyholders. If, for example, Person 1 steals something from Person 2, then the rights enforcement agency of Person 1 would contact the rights enforcement agency of Person 2. Because these two agencies interact with each other all the time, they would have a specific agreement and contract in place before the robbery even happened. This agreement would state the private court or arbitration system that they wish to utilize should there ever be a conflict between their policyholders. This agreement would already be in place because getting into physical altercation to battle other agencies is expensive, and as profit-maximizing firms, they would want to minimize costs. This agreement would be adhered to because the agencies are playing a repeated game. They are constantly going to keep interacting with each other. So, they have an incentive to keep adhering to their agreement in order to get reciprocity of adherence and to avoid expensive physical altercations. The private courts or arbitrator that the two agencies use for the dispute between Person 1 and Person 2 would be utilized because it has a history of being a good and fair court. The court competes with other courts in the marketplace seeking to get rights enforcement agencies as their customers. Rights enforcement agencies also want to compete and attract customers, policyholders, so they will only pick a court if it meets the demands of the consumers. All of this would create a situation where the market makes the laws and rules in society. The private court would create laws that respond to the demands of the marketplace. The law will reflect consumer tastes and preferences. Because the market is creating law, this would lead to efficiency. Competition and profit incentives equilibrize supply and demand, they minimize costs, they maximize quality, and they optimize the output of law. There are positive moral implications for a privatized legal system as well. Privatized law avoids government force and coercion. A legal system built on voluntarism is very moral. If law was privatized, then individual consumers get to decide for themselves what the system of law should be through their votes in the marketplace. This minimizes the harm of the tyranny of the majority and allows for individualized preferences to be acquired. People can interact with each other in mutually beneficial and voluntary market transactions. In a democracy where the government makes the law, the jurisprudential views and beliefs of 51% of the population can be forced on the 49%. So, there are many laws and legal concepts that exist with almost half of the population either not voting for them or not consenting to them. If laws are disobeyed, the government sends people with guns after you to ensure enforcement. Under Dr. Friedman's system, people with guns would still come after you to enforce a private court judgment. The difference is that each individual has consented to this prior to it happening. Consumers voluntarily get a choice in choosing their rights enforcement agency, the court system that the agency uses, and therefore the law that applies to them. People get more of a direct choice in the marketplace than with the ballot box when they vote for politicians and judges. Moreover, the marketplace is better equipped for efficiency than the government. The government has political incentives. The marketplace has profit and competition-based incentives. This allows for the efficient use of resources and creates efficient outcomes. The current legal system is overrun with red tape, politics, and bureaucracy. In order for Congress or an agency to pass a law or rule, a long and tedious process must happen. It takes a lot of effort and time to pass a law or for an appeal process in court to take place. The market, on the other hand, must act quickly in order to stay competitive and maintain adequate profits. Private rights enforcement agencies and private courts need to make changes quickly in order to properly respond to changing preferences from consumers. Innovation and competitive pressures of the marketplace creates quality laws and law enforcement. Efficient legal rules can also help to maximize wealth and outcomes for everyone. Furthermore, the more efficient a law is, the more likely it is to be adopted by other private courts. Efficient rules and laws are very attractive to others as they can help to minimize costs and maximize wealth. Private arbitration is currently often used by businesses. Businesses put arbitration clauses in contracts because they find them superior to the normal public court system. Private arbitration can be less expensive and more efficient. Public courts can be backed up due to the large number of people using them and the lack of adequate funding. Public courts also have a lengthy and complex process. Private arbitration that is funded privately can have the adequate money to fund it and is a good option for many businesses and private parties. To address more specific concerns surrounding the privatization of the law, look at a specific example by Dr. Friedman on capital punishment. Some people might feel that the risk to themselves of being convicted, correctly or incorrectly, and executed for a capital crime outweighed any possible advantages of capital punishment. They would prefer, where possible, to patronize protection agencies that patronize courts that did not give capital punishment. Other citizens might feel that they would be safer from potential murderers if it was known that anyone who murdered them would end up in the electric chair. They might consider that safety more important than the risk of ending up in the electric chair themselves or of being responsible for the death of an innocent accused of murder. They would, if possible, patronize agencies that patronize courts that did give capital punishment. One can imagine an idealized bargaining process for this or any other dispute as follows. Two agencies are negotiating whether to recognize a pro or anti-capital punishment court. The pro agency calculates that getting a pro-capital punishment court will be worth $20,000 a year to its customers. That is the additional amount it can get for its services if they include a guarantee of capital punishment in case of disputes with the other agency. The anti-capital punishment agency calculates a corresponding figure of $40,000. It offers the pro agency $30,000 a year in exchange for accepting an anti-capital punishment court. The pro agency accepts. Now, the anti-capital punishment agency can raise its rates enough to bring in an extra $35,000. Its customers are happy since the guarantee of no capital punishment is worth more than that. The agency is happy. It is getting an extra $5,000 a year in profit. The pro agency cuts its rates by an amount that costs it $25,000 a year. This lets it keep its customers and even get more, since the savings is more than enough to make up to them for not getting the court of their choice. It, too, is making a $5,000 a year profit on the transaction. As in any good trade, everyone gains. Another specific concern with privatizing the law is that bad criminals like murderers and rapists would be protected. They would be protected because they would seek a rights enforcement agency that allows them to engage in the type of behavior that they desire. Or they will just not purchase agency coverage at all. Dr. Friedman addresses this concern. He notes that there would hardly be enough murderers at any one time to support their own protective agency. One with a policy of patronizing courts that did not regard murder as a crime. Even if there were, no other protective agency would accept such courts. The murderer's agency would either accept a reasonable court or fight a hopeless war against the rest of society. A market-based system would also possibly result in less uniformity of law. This is another potential concern with privatized law. Under the current system, law is uniform. Federal law applies in the entire country, and state laws apply in the entire state, etc. Dr. Friedman notes that another objection is that a society of many different legal systems would be confusing. If this is found to be a serious problem, courts will have an economic incentive to adopt uniform law, just as paper companies have an incentive to produce standardized sizes of paper. New law will be introduced only when the innovator believes that its advantages outweigh the advantages of uniformity. Uniformity in the marketplace is already very apparent today. Competition that responds to consumer demands often results in homogeneous goods that are good substitutes for one another. Knockoff brands are usually very similar to the more mainstream brand, whether it is with cereal or cell phones. However, there's also variation in products. This can be good because it gives consumers more choices and does not create a one-size-fits-all solution. While there are clear advantages to privatizing law, to me, it seems somewhat unworkable and not extremely likely to succeed in practice. However, at a minimum, there may be room to adopt some of Dr. Friedman's ideas. For example, society could expand the use of private arbitration clauses in contracts. This would allow for the use of an adjudication system that is potentially more efficient and superior to the court system created by government. It may also be practical to allow people to opt out of state-made law in some circumstances. State-made law would act as a default that could be opted out of in certain situations. If two individuals want to purchase coverage from their own rights enforcement agency, then they should be allowed to do so. This coverage would only extend to situations where a transgressor and a victim both have their own rights enforcement agency and there is no uncovered third party involved. For example, say person A and person B have each purchased their own rights enforcement agencies that cover assault and battery. If person A assaults person B, then the laws of the state would not apply. Dr. Friedman's ideas about private coordination between the two rights enforcement agencies would apply, and the two parties would wind up in a private court that was previously agreed to by the agencies, and so on and so forth. If, however, person A assaults person C, who has no rights enforcement agency, then both parties would operate under state law and utilize the normal courts. Allowing for this type of application of Dr. Friedman's ideas would address its potential problems while still allowing society to reap its benefits. The poor would still be protected by courts, even if they could not afford a rights enforcement agency, and those who can purchase an agency get to utilize a voluntary and mutually beneficial system that is potentially more efficient. Overall, Dr. Friedman's ideas about the law are thought-provoking. Privatizing the law could create an efficient system that allows for competing jurisprudential views on the law to thrive. Competing firms could each tailor their coverage to the demands of consumers, thereby creating a diverse legal system, but still maintaining some uniformity of law. The current legal system utilizes the political process to implement jurisprudential ideas. Maybe a profit incentive for law would be better than political incentives. A truly privatized legal system has not occurred before, so predictions about its success or failure are just that, predictions.